So, I was watching a video the other day. It was a video by the Army Fisherman. And I'm watching this video and I'm thinking to myself, what is this that he's talking about?
This is a public service on YouTube.
This is a public service?
This is a public service.
I saw that header behind his head and I thought, well, what the hell's going on and why isn't he talking about this?
For protection against domestic and sexual violence, stalking?
Well, it kind of goes through all this stuff.
Oh, stalking.
It's going to be on, yeah, the stalking is the one.
Stacey Lopez, I work for the South Daytona Police Department. I'm the records custodian and assistant to the chief record supervisor there. So it's a professional relationship.
Okay, so you've encountered or responded in your work capacity?
Yes, ma'am.
Okay. And if you would just explain why you believe an injunction for protection is necessary.
Should I come up here or should I stand here? Stay here? Okay.
Wherever you come to the podium.
So, Your Honor, my name is Stacey Lopez. I am requesting a permanent injunction for protection against stalking pursuant to Florida Statute 784.0485. I am a records supervisor, assistant to the chief of South Daytona Police Department, and a public service employee. The respondent, self-identified First Amendment auditor.
Whoop-de-doo.
Whoop-de-doo.
Yeah.
Whoop-de-doo.
Yes.
My First Amendment auditor, who has repeatedly targeted me in a manner that has caused me substantial emotional distress and put me in fear of my own safety and disrupting my ability to perform my essential job functions.
Directed at Ms. Lopez. If she left the department tomorrow, he would go in, get his public records, not deal with her. None of this wouldn't exist. This is a personality conflict. You know, Judge, the case that always brings to mind, I like to quote this conduct specifically. Let me find it here. It's in the case, and again, I'm sure the court's familiar. I'll bring a copy up here in a moment. Jones versus Jackson. This was an injunction dealing with stalking, emotional distress. I always like the language in Judge Alderbrandt's concurring opinion. It might occasionally be helpful if the circuit court had powers to enter an order requiring adults to act like grown-ups. But a permanent injunction for protection against repeat violence cannot be used simply to compel civility and common decency. That's what this is about. Could Mr. Dickinson perhaps tone down some of the rhetoric and the language and such in the back and forth? Sure, he could. I've advised him he should, just as professionals in his role, to not have to end up in circumstances like this. However, it's not illegal. It's not stalking to send an email that says F you or say things we don't like. And that's, again, what this is really about, is civility and decency, which has deteriorated to the point, here we are, in court with witnesses, everything else is taking place. It doesn't warrant a stalking injunction, perhaps a stern, hey guys, let's quit this, or we're gonna be back here, this could happen again. Absolutely, I get it, but the merits are just not met. The legal burden has not been met in terms of Ms. Lopez to say to the court.
What the court's determining is whether you have presented sufficient evidence to support an injunction.
So I believe that I have submitted sufficient evidence based on the emails that I have presented, the copies of the continued behavior even after trying to have decent communication, and he continues to send out the emails to other city employees and officials. It absolutely meets the criteria that an injunction should be put into place. There should be some sort of protection for me against this type of behavior. You should be able to be a First Amendment auditor, but you should not be able to harass me as a public service employee.
Well, I appreciate that. I appreciate your testimony. Based on the state of the law, I do not think the evidence is sufficient to support an injunction for protection against stalking, so it will be dismissed.
Right.
All right, as I said before, I'm not condoning any language or tone or behavior. It's just, does this meet the legal definition of law, and it does not. All right, so it is dismissed.
Thank you.
You need to go find out what's going on here. Why isn't he talking about it? Right? So, we got this.
This is a public service on YouTube.
This is a public service?
This is a public service.
That cleared. Welcome into the show. So, I was watching a video the other day. It was a video by the armed fisherman. And I'm watching this video and I'm thinking to myself, what is this that he's talking about? What is this stuff that he's talking about? So I did a little search. Is everybody aware of what's going on with the armed fisherman right now? Everybody know what's going on? It looks like there's some more kangaroo bullshit going on. So I saw that in the video and I said, oh, well, what's this stuff? Need to go find out what's going on here. Why isn't he talking about it? Why isn't he talking about it? Why isn't he talking about it? Right? So we got this armed fisherman. We've got stalking and a public records request or public records violation. I saw that header behind his head and I thought, well, what the hell's going on and why isn't he talking about this? So I looked at it and it says stalking and a public records violation. Okay, well, that's interesting. I didn't realize the public could even be charged with violating the public records law, chapter 119. So a law that doesn't even apply to the people. The kangaroos out in Pinellas County, Clearwater specifically, they want to use the law as a weapon to silence their critics. So what's going on is apparently, I don't know how much of it, if anybody knows the facts, please let me know, because I don't know if Soliaker isn't allowed to talk about this, or if he just isn't talking about it because his lawyers have asked him not to talk about it. But we still need to talk about it because it's ridiculous. So the stalking is against this public official. They attack you. So they hit him up with a stalking charge, misdemeanor stalking in the first degree, and a public records violation. Okay, so I'm going to go out on a limb and I'm going to assume that all of the stalking took place at public buildings. And I believe that's where he was actually arrested on these charges, was at the city council meeting. So he's never, to my knowledge, please correct me if I'm wrong, whoever happens to know, but he's never had any interaction with this woman out in public other than at the city council meeting. He's never gone to her house. He's not going to her place of worship, not going to the education place, not going to daycare. Right? We know Solo. We know Soliaker. Does it seem like, have we ever known him to be a stalker? These people are into their feelings. And that's what it is, right? They're into their feelings. And now Solo can't go to the meetings, right? Because I'm assuming well, not assuming. Listen to this. Conditions of release on GPS monitoring. Dude's on GPS monitoring for criticizing a public official, and I guess for abusing the public records process. When do we get to start charging these sovereign citizens with violating the public records law? I've never ever seen anybody get charged with a violation of Chapter 119. And the one time I do see it, it's against the person that is lawfully using it in order to uncover lawlessness within inside the government. And what is the response from the government? Well, it's lawfare. Let's weaponize the law. Let's weaponize the legal process to get a man to stop speaking. Right? I haven't heard him talk about Clearwater in, I don't know if it's been since then, but here, let's go back. So, Clearwater playlist, it's got 75 videos. And there you go. That's for everybody a little later. All right, so let's see, where's the most recent? 4 months ago. We've seen John Felix, we've seen Warren Sapp, we've seen a whole host of people in Clearwater. Mr. is it Beluva? I can't remember his name. But these are these are just Americans coming in to exercise their constitutionally protected rights. And does the Clearwater Police Department, do they protect constitutionally protected rights? No. No. Protecting constitutional rights is not something that the city of Clearwater thinks is in their purview. So we've got these charges. He's on GPS monitoring. He can't have contact. Looks like we've got some motions. Motion to withdrawal. Motion to hearing. Motion to remove the monitor. So this was filed. I don't know, like 2 weeks ago. Coming up on 2 weeks ago. Defendant was arrested on July 20th. July 10th, sorry. Allegations of stalking. The alleged victim in this case works for the city of Clearwater as a public official. The defendant is a Port St. Lucie, Florida, and does not have a criminal conviction to the best of the undersigned counsel's knowledge. He lives on the other side of the state, roughly 180 miles and over 3 hours away by car. They're going to make... Clearwater is... These people are warped. Okay, so the conduct in this matter is arguably protected by the First Amendment. The state has not filed an information in this case despite Mr. Taylor's arrest 6 weeks ago. 6 weeks ago. Alright, so... I guess I'm confused. If there's no information, has he been charged? I mean, he's been charged, right? He's on GPS monitoring. Surety bond, complaint. Let's read the complaint. We'll read the complaint and then we'll read the motion to... what was it? One at a time, I guess. No. And the motion to remove GPS monitoring. Alright, I don't want to put that. I'm not going to put that up there because it's got all of his personal information in there. If you guys want to see the actual complaint, then Pinellas County criminal, you can search them up. So I'm not going to go through that because I'd have to redact all his personal information. I'm not really in a position to do that right now. So the state has not filed information in this case despite Mr. Taylor's arrest 6 weeks ago. Mr. Taylor is subject to GPS monitoring in addition to no contact orders barring him from 1,000 feet of the alleged victim's residence and place of employment. The GPS monitoring has placed a significant financial burden on Mr. Taylor and is not necessary to protect the alleged victim in this case, as the only place Mr. Taylor ever encountered the victim in person was in and around city council chambers in Clearwater, Florida. Let me get her email. I gotta send this cunt some emails. This dirty cunt thinks that she can just do whatever the fuck. So that's fucked up. She's dirty as fuck. So he's only ever seen this person at a public meeting open to the public where he was allowed to be. Now he's not allowed there. There have been no pre-deprivation, post-deprivation. Nobody cares about his rights. We're just gonna get him away from Clearwater. We need to have this guy stop coming to Clearwater, stop talking about the lawlessness in Clearwater. And how do we do that? Well, we'll throw some crimes at him. We'll just throw some crimes.